arrest or detention. On that case, you're facing up to a year in jail and or a $4,000 fine. You're also charged with failure to identify oneself to a peace officer while being a fugitive from justice. That kicks it up to a Class A, so you're also facing a year and or a $4,000 fine on those cases as well.
Welcome back to the channel. Today we're witnessing a case that escalates fast, a routine traffic stop that turns into a high-speed chase, fake identities, and a violent aggravated robbery with a firearm. Mr. Davis is facing multiple charges across different cases, and the judge is about to lay down the law hard. Will he walk free, or is he looking at serious jail time? Buckle up, because this courtroom showdown is about to get intense.
We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. On January 31st, 2025, the officer observed the defendant's vehicle run a red signal light at the 3400 block of Live Oak Street in Harris County, Texas. The officer further observed the vehicle completely failed to stop at a red signal light and activated his emergency equipment and conducted a traffic stop. The officer made contact with the defendant, who was observed to be behind the driver's seat of the vehicle, and the defendant stated that he does not have his identification card with him, and the defendant gave a fictitious name of Fisher Leroy, with date of birth January 1st, 2006. The officer ran the name through NCIC and found a DPS picture that does not remotely resemble the defendant. The defendant was asked if he was given the correct information, and the officer walked back to his patrol vehicle to double check, and the officer then observed the defendant exit the vehicle and sprint away despite giving him orders to stop. The officer ran after the defendant and observed the defendant get into another vehicle, the passenger side. The other vehicle drove away, and the officer gave the last direction of travel over the radio, but was not able to locate the vehicle. The officer walked back to the defendant's vehicle, secured it, and conducted an inventory check, finding a debit card inside with the name Kendrick Davis. The officer ran the name through NCIC and found a hit with a date of birth of 2/10/2003 with multiple Class C warrants, and ran a driver's license check with the defendant's picture and with date of birth. The DPS picture matched the defendant, and he was able to positively ID. And that's it, Your Honor.
So I'm going to find that there's probable cause to go forward on both of your cases. The reason I'm bringing you out now is because there's no bond that's set on your cases, and we have to set you a bond. One of the things that I use to determine on what to set a bond is how dangerous you are, because I've never met you before. I don't know you. And all I know is that you've got a birthday in 5 days. So he's on bond for an aggravated robbery now, right?
Yes, Judge. It's my understanding, I think it was a 2B, it looks like. I don't believe bond conditions and everything were put in place until a few days ago.
Okay.
Okay, let's pause and break down what's happening here, because this case has layers. Mr. Davis is facing evading arrest or detention and failure to identify himself to a peace officer while being a fugitive from justice. Both of these can carry up to a year in jail and $4,000 fines each. But here's where it gets wild. During the traffic stop, he gave the officer a fake name, Fisher Leroy, and when the officer went back to verify the information, Mr. Davis literally jumped out of the car and ran. Then he hopped into a getaway vehicle that sped off. The officer eventually discovered his real identity, Kendrick Davis, through a debit card left in the abandoned vehicle. And here's the kicker. The judge is about to reveal that Mr. Davis has an active aggravated robbery case pending. This isn't just about running from a traffic stop. This is about a pattern of evasion and violence. The stakes just went from bad to catastrophic. What would you do if you were in the judge's position? Drop your thoughts below.
So the charging instrument was filed November 13th of 2024. I think that you may well be right. In that case, it says here, Kendrick Richard Davis, hereinafter styled the defendant heretofore on or about August 12th, 2024, did then and there unlawfully while in the course of committing a theft of property owned by yada, 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 with intent to obtain and maintain control, intentionally and knowingly cause bodily injury to the complaining witness by using and exhibiting a deadly weapon, namely a firearm. Complainant McSweeney advised that defendant Davis proceeded to pull a pistol from his waistband and pistol whip him with it multiple times on his head and face area, causing multiple cuts and bruises to his head and face area. As he proceeded to fall down on the ground, he continued to strike him in the head and face area with a closed fist and then stomp on his face with his foot. Complainant McSweety stated that he was in fear for his life and felt severe head pain as a result of the assault. I see that he has also picked up an evading arrest in a motor vehicle
Yes,
the
Judge.
day after our two cases. Oh, I guess that's how they caught up to him, right?
That's how
They
they
must
caught up
have.
to him, they found him, and that's when they arrested him on that, and then he got picked up on, I believe.
Okay, so what happened in that case? Is he like driving 100 miles an hour? Is he just?
Yes, Judge, it says that the officer observed the defendant conduct an improper turn and failed to turn into the correct designated lane. They activated their lights and sirens, and the defendant evaded at speeds of 90 to 115 miles per hour for 3.5 miles on the highways and multiple residential and business streets.
Hold on. Did you just hear what the judge read? This aggravated robbery case is absolutely brutal. According to the complaint, Mr. Davis pulled a pistol from his waistband during a theft and proceeded to pistol whip the victim multiple times on the head and face, causing cuts and bruises. But it doesn't stop there. When the victim fell to the ground, Mr. Davis continued beating him with a closed fist and then stomped on his face with his foot. The victim stated he was in fear for his life and suffered severe head pain. This is violent, premeditated assault with a deadly weapon during the commission of a crime. And here's the insane part. The very next day after the two current cases we're discussing, he picked up another evading arrest charge, this time in a motor vehicle, driving between 90 to 115 miles per hour for 3.5 miles through highways and residential streets. This man is a danger to everyone around him. The pattern is undeniable. What do you think the judge should do here? Let me know.
Okay. I think that you are an extreme danger to our public, and I'm going to do everything in my power to protect our public. The first thing I'm going to do is I'm going to order you not to drive. You will be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what is going on in your life. I don't care if there's a burning building. You have to say 50 kittens. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months jail and a $500 fine every time you get into a car and drive. Do you understand?
Yes, sir.
I'm also putting in this affidavit that you're not supposed to be in possession of any weapons as well. If I find that you have a weapon, because I don't know if you're going to get out or not, and because these cases, because of the nature of the aggravated robbery, because of the nature of this one, I'm making his bonds high. I'm going to set them at 20,000 each.
So can I make an argument?
Yes,
Okay.
absolutely.
you,
I
Judge.
don't want to get ahead of myself, please. Yes.
So I was appointed to Mr. Davis this morning. I was able to talk to him a little bit in the holdover. We are requesting PR bonds for both of the cases. He's 22 years old. He's lived in, or I'm sorry, 21 years old. He's lived in Houston his whole life. He has a lot of family in Houston, his grandparents, mom, daughter, and siblings. Prior to being in custody, he was working at Builders First Source for around a month. Mr. Davis also lives with his grandfather who has cancer. Mr. Davis is his caretaker, is my understanding. Mr. Davis has no savings and was found to be indigent by the court, so we are requesting a PR bond.
This is where the judge draws the line in the sand. Listen to how clear and direct the language is. I don't give a rat's behind what is going on in your life. I don't care if there's a burning building you have to save 50 kittens. The judge is making it abundantly clear that Mr. Davis is not to drive under any circumstances. No excuses, no exceptions. If he violates this order, he's facing an additional 6 months in jail and a $500 fine for contempt of court every single time. The judge is also prohibiting him from possessing any weapons. Then comes the defense attorney's turn. He's doing his job, advocating for his client, mentioning that Mr. Davis has family ties in Houston, works at Builders First Source, and is his grandfather's caretaker who has cancer. The defense is requesting PR bonds. That's personal recognizance bonds, which means release without having to post any money. But given the violent nature of the aggravated robbery and the multiple evasion charges, do you think the judge is going to grant that? Spoiler alert, probably not. What would you decide?
I think that he is an absolute, just a complete danger to our public. I can't possibly give him a PR bond due to the nature of both of the charges that you are facing now. I think that you're a flight risk. You've done everything in your power to evade capture. You've produced false names. So I find by clear and convincing evidence that you're an extreme flight risk. You're a danger to our community. And I'm going to set your bonds each at $20,000. I don't know if you're going to be able to post bonds, but if you do, I'm going to order you under house arrest if you do get out. And I'm going to order you to obtain a GPS monitor on your ankle. Like I said, you will be signing an affidavit with me today, promising me you're not to be in possession of any weapons and not to drive any vehicle whatsoever for any reason. If you do, I can have a contempt hearing. Do you understand?
Yes, sir.
The felonies are set for April 7th. I don't like to set them out too far just in case. If you want to, we can do up to 30 days. It's up to you.
That's perfect.
And then we'll come back. I don't know. We'll see what circumstances have changed, and then we'll go from there and just keep us in the loop.
Okay, thank you.
All right. I need you to sign this for me. I need him to sign bond finished with Felicia, and then after that, it's pretty done. Okay.
Wait, excuse?
Yes, ma'am. And thank you for everything.
And there it is, the judge's final decision. Despite the defense attorney's plea for PR bonds, the judge categorically refuses. The reasoning? Mr. Davis is deemed extreme flight risk and a complete danger to the public. The judge cites clear and convincing evidence. Fake names, running from police, high-speed chases, and a violent armed robbery. The bonds are set at $20,000 each. That's $40,000 total. But even if Mr. Davis somehow manages to post bond, the judge isn't taking any chances. He'll be under house arrest with a GPS ankle monitor. No driving, no weapons, no exceptions. The judge is essentially saying, if you get out, we're watching your every move. And if he violates any of these conditions, straight back to jail with contempt charges on top of everything else. This is judicial oversight at its strictest. The judge is balancing public safety with the defendant's rights. And in this case, public safety wins decisively. Do you think the judge made the right call, or were the bond conditions too harsh? Sound off in the comments. VO6, professional summary and call to action, 100+ words. All right, let's wrap this up and review what we just witnessed in this courtroom. Mr. Kendrick Davis came before the judge facing evading arrest, failure to identify as a fugitive, and an underlying aggravated robbery case where he allegedly pistol-whipped and stomped on a victim during a theft. Add to that a separate high-speed chase reaching 115 miles per hour through residential areas, and you have a defendant the judge considers an extreme danger to the community. Despite his defense attorney's arguments about family ties and being a caretaker for his sick grandfather, the judge set bonds at $20,000 each and imposed strict conditions: house arrest, GPS monitoring, no driving, and no weapons possession. This case demonstrates how judges weigh multiple factors: severity of crimes, flight risk, public safety, and defendant's circumstances when making bond decisions. The system tries to balance individual rights with community protection. And in cases involving violence and repeated evasion, the scales tip heavily toward caution. If you found this case as gripping as we did, make sure to smash that like button. Drop your thoughts in the comments below. Do you think the judge's decision was fair or too extreme? And don't forget to subscribe for more incredible courtroom breakdowns. We got tons of jaw-dropping cases coming your way. So hit that notification bell, and let's dive into more legal drama together.